5 seconds to go. The Honorable Court, while dealing with the present writ petition, observed that the question before it was not merely of administrative propriety but of fundamental fairness in the exercise of official discretion. The petitioner, a government servant of over 20 years of unblemished record, had challenged the order of suspension issued against him on the ground that the same was arbitrary, malafide, and in gross violation of the principles of natural justice. The learned counsel appearing for the petitioner submitted that no preliminary inquiry was conducted, nor was any material placed before the competent authority justifying such drastic action. It was contended that suspension cannot be used as a punitive measure but should be an instrument to facilitate free and fair inquiry. The learned counsel relied upon several judgments of Honorable Supreme Court to emphasize that suspension must be resorted to only in exceptional cases where the continuance of the employee in office would prejudice the investigation or inquiry. On the other hand, the learned counsel for the respondents submitted that the impugned order was issued in the larger interest of the department and that the allegations against the petitioner were serious in nature. It was argued that the competent authority had applied its mind to the material available on record before passing the order, and therefore no interference by this court was warranted. The court carefully examined the rival submissions and perused the documents annexed with the petition. It observed that while the authority is empowered to place an employee under suspension pending inquiry, such power must be exercised reasonably and not mechanically. The court noted with concern that in many cases suspension is ordered without recording specific reasons, which not only causes undue hardship to the employee but also results in administrative inefficiency. The Honorable Judge observed that the principle of fairness is the cornerstone of administrative law and that every action of the state must satisfy the test of reasonableness under Article 14 of the Constitution of India. It was further held that suspension, though not a punishment in itself, has far reaching consequences on the reputation and livelihood of an individual and should therefore be resorted with utmost caution. The court referred to the landmark judgment of the Supreme Court in Ajay Kumar Chaudhary versus Union of India, wherein it was held that suspension cannot be indefinite and must be reviewed periodically. The court also drew attention to the fact that in the present case, more than 1 year had elapsed since the order of suspension, yet no charge sheet had been served upon the petitioner. Such delay, the court remarked, amounted to gross administrative negligence and violated the constitutional guarantee of speedy justice. After considering the facts in totality, the Honorable Court held that the continued suspension of the petitioner was unjustified and contrary to settled legal principles. The court therefore quashed the impugned order and directed the respondents to reinstate the petitioner in service with all consequential benefits while reserving liberty to proceed with the departmental inquiry in accordance with law. The court also observed that if the authorities desired to continue the inquiry, it must be completed within a period of 3 months from the date of receipt of the order, failing which the proceedings shall stand automatically dropped. Before parting, the court made an important observation that arbitrary use of suspension power not only demoralizes honest officers but also shakes public confidence in the fairness of the administrative system. The court urged all disciplinary authorities to bear in mind that governance should be based on fairness, not fear. Every officer has a right to dignity, and no one should be subjected to unnecessary humiliation in the name of procedure. The judgment further emphasized that supervisory officers must ensure accountability in decision making and that periodic review committees be established to examine the necessity of continuation of suspension in each case. The Honorable Court also issued directions to the state government to frame comprehensive guidelines to regulate the exercise of suspension powers in order to bring uniformity and prevent misuse. It was further directed that no employee should remain under suspension beyond a period of 6 months unless reasons for extension are recorded in writing and communicated to the concerned person. The court reminded that transparency and fairness are the lifeblood of good governance and administrative action devoid of these virtues cannot stand the test of law, finally expressing concern over the increasing number of cases where officers are kept under prolonged suspension without substantial progress in inquiry. The court recommended that a monitoring mechanism be established within the Secretariat to ensure timely review of all pending disciplinary matters. The court concluded its judgment by reiterating that justice delayed is justice denied, and that every authority, while exercising administrative power, must remember that behind every file lies a human life affected by its decision. The writ petition was accordingly allowed with no order as to costs, and the registry was directed to forward a copy of this judgment to the Chief Secretary of the state for necessary compliance. In compliance with the aforesaid directions, the state government filed an affidavit indicating that steps had been initiated to draft a comprehensive policy for regulating the suspension of government employees. The court, however, observed that mere formulation of a policy would not suffice unless it was implemented in letter and spirit. It stressed that accountability mechanisms must be built into the system to ensure that reviewing authorities periodically assess whether the suspension continues to serve any administrative purpose. The Honorable Court also expressed the view that training programs should be organized for disciplinary officers to sensitize them regarding constitutional mandates and judicial precedents governing service jurisprudence, it further remarked that the true measure of governance lies not in the number of punitive orders issued, but in the fairness and transparency of the process.